Hearing the appeal of Tesco Stores Limited against the Union of Shops and Allied Workers and others.
Yes, Mr. Siegel.
Please, the Court. I appear with Mr. Brittenden, King's Counsel for the Appellants, my learned friends Mr. Degar Robinson, King's Counsel, Mr. Rogers, King's Counsel, and Mr. MacLeod appear for the Respondent. My Lord, the Court has read our case dealing with how we say the Court of Appeal fell into error and why this Court ought to restore the decision of the High Court. We want in these oral submissions mainly to respond to the Respondent's written case. The first issue between the parties concerns what we style the industrial and statutory backdrop to the agreement for permanent retained pay in 2009. It's important to understand why that background might be relevant. The Respondent is clearly alive to the unattractiveness of the proposition that the agreement to permanent retained pay could at any time be negated by the expedient of dismissal and offers to re-engage on terms without retained pay. The Respondent, therefore, not the claimant, suggested that the availability of a statutory remedy for unfair dismissal was a relevant matter because, it argues, employees who accepted the offer of retained pay in consideration for not receiving redundancy payments and instead moving to a new place of work could not be fairly dismissed shortly after that move and were thus adequately protected in that regard. The claimant's position is that the potential to bring unfair dismissal claims does not assist in construing the retained pay term, which can and should be interpreted solely by reference to normal contractual principles, focusing on the natural meaning of the words used, read in light of relevant admissible documents, insofar as the words used are ambiguous. However, if this Court is to have regard to the supposed availability of unfair dismissal claims, it is important, we say, to understand the scope of that statutory protection in the present context. Three preliminary uncontroversial points. As a statutory remedy in the social political field, its parameters are subject to regular change. Second, it's always been subject to a cap on compensation, which has over the years been redefined and reduced. Third, it's subject to claimants having worked for a certain number of years for their employer, which has varied over recent decades between 1 and 2 years. Thus, a worker who had accepted the offer of retained pay might not even be permitted to claim unfair dismissal if he was dismissed and offered re-engagement before he had accrued sufficient continuity of employment, and even if he was able to bring and succeed in a claim for unfair dismissal, his recoverable damages might well not cover his actual losses. Much more germane to the present case, however, is that the prospects of claims for unfair dismissal by these claimants succeeding in any real-world circumstances would be next to nil. The short point is that the same reasons Tesco relied on and the same process it undertook in 2021, which it implicitly accepts would provide a robust defence to unfair dismissal claims, could, if its construction of the retained pay term were correct, have been relied on equally by it in defending unfair dismissal claims in 2011, say. The need to reduce inequalities of pay, to harmonise terms and conditions, and to simplify payroll would have constituted just as compelling lawful reasons for dismissal in 2011 as in 2021. As to the fairness of relying on those reasons, as my lady knows, it is notoriously difficult to succeed on that issue in unfair dismissal claims of this sort. Employment tribunals have been repeatedly cautioned not to examine the commercial rationale of the employer's decision to dismiss, provided there was a sound business reason. Also, not to focus on the difficult consequences for the workers. The appellate courts have held an employer may act reasonably, and thus the dismissals be fair, even though the employees themselves act reasonably in not accepting re-engagement. In practice, generally the only line of attack open to claimants in these cases is to challenge the degree of the employer's transparency or the extent of its consultation with employees or their unions. And importantly, one must remember that on the respondent's case, the retained pay term has no temporal dimension. Permanent, will remain, never mind guaranteed for life, means only, the respondent says, not subject to collective bargaining. So it's not as though unfair dismissal claimants could assert at any point in time that dismissing them to remove retained pay was some sort of breach of expectation or promise, even in the non-legal sense. They would be in exactly the same position on the respondent's case as if the negotiations about retained pay had never happened and they had simply been given the choice between redundancy and moving to the new distribution centres on their existing terms. The respondent does not...
That's right, is it? I mean, one might think perhaps that within the regime of unfair dismissal, one could differentiate, for example, between a dismissal almost immediately and one that is, I believe on the facts of this case, is it 10 or 11 years on? I'm not quite sure what the facts precisely are, but about that period. That would be something that perhaps could be differentiated within the unfair dismissal regime, could it not?
Well, my lord, if one pushes it to extremes, as the respondent in its written case does, almost immediately, I mean, the respondent hypothesises on day one or without notice or without proper consultation, then one can see it might be so. But if one takes the equal pay cases, for instance, Bainbridge, which both sides refer to, where the comparators were put on protected pay, and the issue was whether that protected pay was lawful as it continued over any period of time. If Tesco had said, for instance, I said 2011, I took that as a year or so after the event, allowing, of course, for proper contractual notice, a period of consultation over several months. But if Tesco in 2011, after that process, had dismissed the claimants, yes, I say they would have absolutely no chance of succeeding in unfair dismissal claims. And we say the respondent doesn't face that obvious fact, but instead takes, we say, bad or irrelevant points. To take my lord's point, the respondent does rightly hypothesise that if it had dismissed the claimants on day one, or without any notice or consultation, yes, that would have been unfair. But such hypotheses are artificial and do not address the issue. Then the respondent suggests in general terms that whether dismissals are fair is unpredictable. And then, we say oddly, cites 3 unreported employment tribunal decisions, 2 of which concerned single employees, and the only one of which that has any remote resemblance to the present case, decision of Marzek, I won't take you to it, was a case where the 3 claimants had resigned when threatened with dismissal, and where the tribunal's finding that those constructive dismissals were unfair was based on the failure of the employer to offer any contractual notice, misleading communications from the employer such as to constitute a repudiatory breach of the trust and confidence term, and there being no evidence that the proposed pay cuts were for a sound business reason. And that appears to be the best authority the respondent can identify to support its argument. Finally, the respondent suggests that the claimants are in effect highlighting the inadequacy of the unfair dismissal regime to protect them. No. It is the respondent who is relying on the supposed adequacy of the unfair dismissal regime as sufficient to protect the claimants from the effects of dismissals, at least for, doesn't know, several years, I suppose, in order to remove their entitlement to retained pay. There is no answer, and the respondent has given none, to the proposition that if the retained pay is to be construed as it contends, the claimants would have had no more protection by means of the unfair dismissal regime from being dismissed in order to remove their entitlement after proper notice and consultation in 2011 than in 2021. All of which is to say simply that the respondent is fixed with the deeply unattractive consequences of its case. that employees who accepted the offer of permanent retained pay in consideration for not receiving substantial redundancy payments and instead moving 40 miles away to a new place of work could indeed be dismissed not long after that move in order to remove their entitlement to retained pay without any legal recourse, or at least none which was based on the promise of permanent retained pay. And, my Lord, as we pointed out in our case, not only did the employment specialist trial judge hold that view, it was conceded at trial by leading counsel for Tesco that on its construction of the retained pay term, it would have been open to Tesco to terminate the contracts shortly after the employees moved with impunity. Now, we accept that does not determine the contractual construction issue. Indeed, we say it's not directly relevant to it, but it puts it in its correct industrial and legal context insofar as that context may be held by this court to be relevant. Moreover, that context is one which would have been very well known both to Usdaw and to Tesco. Some final short points on the background in relation to pay protection more generally. The respondent suggests that the retained pay term in this case was not exceptional as being without taper or time limit because, and I quote, in many cases an employer has employees who are contractually entitled to different rates of pay. But the point about pay protection generally is that it recognises that there is no prima facie reason for maintaining differentials in pay. All employees doing a particular job or range of jobs should be paid the same, but some continue to have a higher rate of pay, agreed for historical reasons, so as to protect them from the effects of a sudden reduction. In such situations, it would be rare, if ever, and the respondent gives no examples, for the level of protected pay to be without taper or time limit. The present case is very different. Tesco was determined to persuade as many workers as possible to move to the new distribution centres rather than take redundancy. The offer of permanent retained pay was made purely as an incentive to persuade them to take that course. Just how determined Tesco was is explained by it at page 407. Under the second heading, the reasons for Tesco commencing this work are the following.
What are we looking at here?
Sorry, my lord, page 400. Oh, sorry.
I know. What is the document?
It is a document created by Tesco's management to explain in 2020 or 21, I can't remember precisely the date, the genesis of the retained pay term. So retained pay was introduced in the first line in order to ensure that the distribution centre network could continue to operate effectively. We had to make sure we did not lose all of our existing colleagues through redundancy. Although many of our colleagues did opt for redundancy, retained pay, which we negotiated as an alternative to a lump sum redundancy payment, was crucial to us being able to retain enough colleagues to avoid serious disruption to our distribution centre network and the wider business. The genesis of the pay protection in this case was unique. Thus, the content also had to be unique. The promise of protection had to be that it would, quote, remain as permanent, as opposed to tapering or temporary, in order to serve as a sufficient inducement for those who could be persuaded to move, and many were not persuaded even by that promise. If one continues reading at 407, the next sentence neatly encapsulates the issue in this case on its merits. These retained pay arrangements, Tesco says, achieved what they were designed to achieve and have enabled us to maintain a stable workforce since. But we feel it is now the right time to phase those arrangements out. Tesco had a commercial objective. In order to achieve that objective, it had to make certain promises. Once that objective had been achieved, it no longer wished to be bound by those promises. At paragraph 8 of the respondent's case on these issues generally, page 132 if you wanted to get it up, on the issue of pay protection, there appears the first variant of what we say is a particularly insidious Aunt Sally erected repeatedly by the respondent. The submission,
Sorry, can you give me the page number again?
It's 132, my lady.
Thank you.
Paragraph 8. You'll see variants of this several times throughout the written case of the respondent. Here it is phrased as the submission that the claimants argue that pay protection equates to a backdoor protection against dismissal. No. The claimants argue only that, by reason of the particular retained paid term, Tesco could not lawfully dismiss them in order to deprive them of the purpose or substance of that permanent entitlement. My lady, my lords, I turn then to the construction of the term. There's nothing between the parties on the relevant legal principles. In construing a term incorporated from a collective agreement, one must adopt an approach which does not flout industrial common sense. Otherwise, the normal principles apply as set out by Lord Neuberger in Arnold and Britton. Page reference is 1087, at paragraph 15 and following. Picking it up just above H, and forgive me if I go through this very familiar authority at some speed, one focuses on the meaning of the relevant words in their documentary, factual, and commercial context. That meaning has to be assessed in light of 1, the natural and ordinary meaning of the clause, 3, the overall purpose of the clause, 4, the facts and circumstances known or assumed by the parties at the time that the document was executed, 5, commercial common sense, but 6, disregarding subjective evidence of any party's intentions. Paragraph 17, about halfway down, one looks through the eyes of a reasonable reader. And at paragraph 19, second sentence, the mere fact that a contractual arrangement, if interpreted according to its natural language, has worked out badly or even disastrously for one of the parties is not a reason for departing from the natural language. And then at paragraph 20, Lord Neuberger makes the point that this is so even if such disaster could have been foreseen, acting prudently and with good advice. As to the admissibility of pre-contractual documents, my Lord Legate, in a fairly recent case, Merthyr Tydfil, the relevant part is 2829, articulated the position at paragraph 52 in this way.
Can I just have the reference again? Sorry.
2829, my Lord, paragraph 52. It is established law that, as stated by Lord Wilberforce in Pren, previous documents may be looked at to show the surrounding circumstances and by that means to explain the commercial or business object of a contract. Skipping a few lines, it is an approach which, as Lord Wilberforce noted, can be traced back at least to Lord Blackburn's judgment in River Wear Commissioners, which emphasised the importance in construing written instruments of seeing what the circumstances were with reference to which the words were used and what was the object appearing from those circumstances which the person using them had in view. One of the many cases cited by the respondent in this context is perhaps worth mentioning. The Dimitris L, the page reference is 2171, considered a circular explaining a tax clause, and Mr. Justice Clark said this in paragraph 21 towards the bottom of the second column. The circular is relevant, therefore, not because it is taken as an accurate statement of the incidence of the tax, but because it indicates the risk with which the clause was designed to deal. Then at the top of the next page, end of the first line, evidence of the aim of the transaction, and in particular the risk that it was designed to address, is, in my judgment, admissible. A commercial party to whom the circular was available would interpret the clause on the basis that it was intended to meet that risk. I turn to the facts of the present case. As my lady, my
I
lords,
think in the Investors' Compensation Scheme case, there was some sort of letter or something that accompanied the contract, and the House of Lords said that that was admissible because people would read the letter.
well, as my lord knows, this case was, I hope not rhetorically suggest, the paradigm, because the relevant documents were produced by Tesco or by Tesco and Usdaw in order to swing a vote. So there was an uncontroversial purpose to explain as clearly as possible to those who were voting what they were voting for. Now, the court knows that the respondent submits that the documentary and other evidence shows that the object of the retained pay term, or one might say the risk the agreement was intended to meet, was solely to ensure that the employees' union Usdaw could not later negotiate away the entitlement it had just secured for them. The first point we make is that appears to challenge a finding of fact made by the judge, if one goes to 231. Paragraph 40, just below E, towards the end of a line, there's a sentence beginning, "True it was." True it was that intention encompassed an intention to remove the entitlement to retained pay from the collective bargaining machinery, which would otherwise admit of the prospect that it could be removed at the will of a majority who did not benefit from it. But that was not the full extent of their intention. It is clear from the undisputed evidence in this case that the mutual intention of the parties was that the entitlement to retained pay would be permanent for as long as each affected employee was employed in the particular role, save in the circumstances expressly articulated in his or her contract. Whether it challenges a finding of fact or not, the respondent's submission is anyway wrong. Leaving aside the inherent likelihood that the risk of Tesco seeking to remove the entitlement by fire and rehire was rather greater than of Usdaw negotiating it away, the contemporaneous documents taken as a whole really are clear. And I regret to say that the respondent's narrative as to those documents in its written case is deeply flawed. It begins, page 151, if you prefer to read along, at paragraphs 79 and 80, by referring to a letter to employees following the conclusion of negotiations and before the critical decision was made. The document is at page 271. Written to the relevant workers, dear colleague.
So what was the date of this?
This is Mr. Hoggan's letter, is it?
It is.
21st of January 2007.
Thank you.
I'm very grateful. (271). It writes of an agreement in the third paragraph that will protect the value of your existing contractual terms and conditions for the remainder of your employment with Tesco, which is not consistent with the respondent's case. And pausing there, one wonders how many workers would have given up their £7,000 redundancy payment and moved 40 miles to the new distribution centres if the director had written instead, "We will protect the value of your existing contractual terms and conditions for the remainder of your employment with Tesco or until Tesco removes them by dismissing you and offering you re-engagement." If the answer to that question is very few, then it follows that is not what the words were objectively intended or understood to mean. But there follows, page 151, paragraph 80 of the respondent's case, an unfortunately selective quote from the Q&A prepared by Tesco that was attached to that letter. The document, the Q&A document, is on the next page, 272. The heading is retained pay. For present purposes, the relevant questions are 6 to 8. So can I please ask you first to look at question 6? One might think the most relevant question in the context of the case as a whole. Will retained pay be guaranteed forever? That question, of course, is framed in everyday language, directed at what became the written agreement that retained pay will remain a permanent feature of their teams. And the answer from Tesco is yes, provided your circumstances do not change. Meaning, as the next Q&A clarifies, if you choose a different shift pattern. There is no suggestion that the guarantee is contingent on Tesco's circumstances not changing. The respondent does not refer to this question and answer in its case. Answer 8 addresses 2 points. The first part of the answer, which is not quoted by the respondent, is the assurance that the protection is long-term, which in context equates to permanent, just as the entitlement in cases like Aspden is sometimes called an entitlement to permanent health insurance benefits, and sometimes, as in Awan, called an entitlement to long-term disability benefits. The second part of the answer, which is quoted by the respondent, is that by making retained pay an individual entitlement, it prevents it being negotiated away collectively. The respondent asserts that the latter is consistent with its interpretation of the retained pay term. Yes, but only because that part of answer 8 addresses the aspect of the retained pay term on which the respondent focuses. The relevant part of the term reads, as I'm sure you will recall, retained pay will remain a permanent feature of an individual's contractual eligibility, presumably meaning entitlement. It will remain, it is permanent in the sense long-term protection for the remainder of your employment with Tesco in the same role, and it is an individual entitlement in the sense it cannot be removed by collective negotiation. My lady, my lords, other parts of other documents relied on by the respondent fall into the same category, insofar as those parts say nothing more than that retained pay cannot be removed by collective negotiation. They give a partial account of the object appearing from those circumstances of agreeing to retained pay, part of the risk that agreement was intended to meet. To use a phrase my learned friends deploy during this part of their case, some parts of the documents, indeed some entire documents, take the position no further forward as to the meaning of the guarantee of permanent retained pay. So, for example, page 154, paragraph 85, the respondent quotes at length a document which gives detail about certain aspects of retained pay, without reference either to it not being subject to collective renegotiation or to it being permanent or guaranteed for your working life in that role. Looked at through the lens of the respondent, presumably it would say that document is not consistent with either party's case. The uncomfortable fact for the respondent, however, is that other parts of most of the same documents, as well as different documents, explain clearly another critical aspect of the object of the parties agreeing to retain pay, another critical aspect of the risk that agreement was intended to meet, namely that it should remain a permanent entitlement, not capable of removal at any time unless the employee's circumstances changed. Another Q&A document at 285 is very telling in this regard. Question 33, the bottom of the page, answers the question, the answer I should have said, answers what does retained pay mean? And the answer is in 4 parts, essentially, beginning 6 lines down. It will remain, the same words as in the finally agreed term, for as long as you are employed in that role, that is, permanently. It cannot be negotiated away collectively. It will increase in line with annual pay rises given to others. It will count towards the amount of all benefits calculated by reference to your pay. Each of those aspects of retained pay is reflected in the final agreed term. The respondent, focusing only on the second and ignoring the first, comments that this document is consistent with its interpretation. It is not. It is consistent only with the claimant's interpretation, which gives effect to all of the guarantees listed. There is even a document at 295, a joint statement, Tesco and Usdaw prepared, which includes 3 of those 4 guarantees, but not the one relating to collective renegotiation. Under the heading Lichfield Depot Retained Pay, the final 2 sentences of that first long paragraph read, "The retained pay is guaranteed for life. It will increase in line with future pay increases. It counts for the purpose of calculating other benefits."
Sorry, which page are you on?
I'm sorry, my lord. It's 295,
295.
headed Joint Statement 23rd February 2007. I was reading from the end of the first paragraph under the heading Lichfield Depot Retained Pay. Guaranteed for life is again a promise in everyday language, one which cannot be circumvented by the expedient of fire and rehire. Faced with not being able to say that this document is even in part consistent with its case, the respondent is reduced to making 2 bad points. It notes this was not a final document because the next paragraph says it was subject to further detailed information. However, that information was only to explain the exact method of calculation, not the principles of retained pay. Then, the respondent points out, guaranteed for life cannot literally mean that. True, just as permanent in the retained pay term does not literally mean till the end of time, any more than permanent health insurance benefits are literally permanent. Both formulations, guaranteed for life and permanent, were meant and would have been understood to mean for as long as you are employed in that role, as several of the other documents state. The same is true of the description of the entitlement, page 277. In the first box, under the heading, "What do I get if I move to Lichfield," etc.
Can I just pick up, I mean, it's coming through a few times that you've linked what is being said to employment in that role. Now, it might be said that the implied term that you are relying on and that the first instance judge accepted goes beyond linking this to being employed in the same role. So it clearly would cover this situation where you've got fire and rehire in the same role, but as I understand it, the term that you are basing yourself on would go far beyond that. So it would include a situation where the employer is making part of the workforce redundant and chooses to select the more highly paid employees on retained pay for that redundancy exercise. Now, in that situation, they're not being retained in the same role, but nevertheless, you would say that that is not permitted.
Well, with respect,
I understand it.
with respect, I think I say both the premise and the conclusion, but not that there's a nevertheless in between them. The contractual right is to continue to be paid retained pay for as long as you're employed in the same role. The term that is to be implied, whether on the judge's formulation or the formulation which amounts to very much the same thing that we've articulated in our written case, limits Tesco's separate power to terminate on notice such that it cannot do so in order to deprive the affected workers of that entitlement. So in the scenario, my lord, that you envisage, And I will come to this because the respondent, as the court obviously knows, has hypothesised various redundancy situations that it wants the court to consider. So I'll come to it in a little more detail. But in the situation that my Lord has just hypothesised, and this is the one, by the way, that the Court of Appeal focused on, if you have a selection process, you have a distribution centre, you've got 100 employees working in the same role, 20 of them on retained pay, 80 of them not, you've got to make 20 people redundant, you choose the 20 who are on retained pay. Yes, that would be in breach of the implied limitation on the power to terminate, because in that situation, Tesco would be terminating in order to deprive people of their right to retain pay. Just as, my Lord, in a permanent health insurance case, if you have 10 employees working in a team, one of which is unlikely ever to return to work and the other 9 of which are working very hard, and you have to make one person redundant, of course you're going to be tempted to choose the one who's on permanent health insurance benefits, but that's not lawful. That is contrary to the term articulated in any of the cases, including that one.
Is that realistic? The person on permanent health insurance benefits wouldn't be a cost to the employer. They'd be on the insurance benefits.
My lady,
why would the employer, in order to reduce costs, select the one who is on permanent health insurance benefits in those circumstances?
well, the short answer to that is the employer very often is paying those benefits. In some of the cases, the employer is effectively self-insured. It's the employer's scheme, and that leaves aside the rather less financially significant consequences of the administration, the dealing with the insurer, the, as often happens in these cases, constant battles with the insurer who's always seeking to repudiate cover. And so the employer, because the employer is the policyholder, not the member, has to go to bat for the member in order to try and persuade the insurer that the member really is incapacitated still. So as someone who's represented several of these permanent health insurance claimants, I can promise the court that even where the insurer is picking up the entire bill, it's often a real headache for the employer, but the insurer does not always pick up the bill. So,
back to the role, the only significance of staying in the same role, as far as I understand it, is that if the person, it's made clear that if the person changes the nature of their job within Tesco, then they'll lose the benefit.
yes, I mean, the simplest, which is specifically catered for, is if you get promoted.
Yep.
But also, there's a more nuanced variant of that. If you, as a night worker, apply to Tesco to instead become a day worker, or vice versa, then your entitlement, I don't think it gets necessarily erased, but it will certainly change and will probably reduce. So, but the words, I hope it's clear, the words for as long as you're employed in that role are not mine, they're Tesco's.
No, we're talking about what they mean.
So, the last document I think I was going to take you to is at 277, the first box under the heading, what do I get if I move? Individual retained pay, protection for life at new Tesco site. Note, by the way, at the bottom of the page, the words, please refer to previous joint statements, such as the ones we've just looked at, for details. In front of the judge, Tesco didn't dispute that it produced this document. Who else would have produced it? Though it now suggests the position is unclear. Taken together, these documents constitute unusually powerful evidence of the commercial object of the retained pay term. At 3743, part of an article by Professors Bogg and Brodie, it was put, we respectfully suggest, well, top of the page, these statements were designed to persuade employees to accept the terms of the collectively negotiated deal. The joint statements, therefore, represented the conclusion of a collective negotiation process rather than positions in the flux of an ongoing negotiation. as joint statements made in the context of collective bargaining, they ought to be treated as highly relevant to identifying the parties' objective intentions and the commercial object of the contract. The short point is this: any employee receiving these documents would have understood that if they accepted the offer, they would be guaranteed to continue receiving retained pay for as long as they wished to remain working in their same role, doing their same shifts at the new distribution centre. And we say it does Tesco no credit that it now seeks to suggest that is not what it intended to convey by those documents. No matter, objectively, that is what was conveyed, as the judge found. Those being, to adopt Lord Blackburn's words, what the circumstances were with reference to which the words were used and what was the object appearing from those circumstances which the person using them had in view. The retained pay term itself is set out within a collective agreement at page 266. And it's common ground that the same term was part of all of the claimant's contracts.
I'm sorry, could you give me the page
266.
again?
266, my lord. And I know you will have read this probably more than once. Retained pay will be uplifted by any future negotiated pay increases. Retained pay is individually calculated and confirmed in individual statements. It's an integral part of contractual terms. It's included in calculations for pensions, etc. Retained pay will remain a permanent feature of an individual's contractual eligibility, subject to the following principles. 1, retained pay can only be changed by mutual consent. 2, on promotion to a new role it will cease. 3, when an individual requests a change to working patterns such as nights to days, the premium payment element will be adjusted. And for the avoidance of doubt, 4, if Tesco makes shift changes, it will not be subject to change or adjustment. It's obvious from those words that the promise that retained pay will remain a permanent entitlement does not equate to the principles, or any one of them, which follow in the numbered subparagraphs, any more than it equates to the prior promises that retained pay will be uplifted by future pay increases and will be included in calculations for pension. Rather, the permanent entitlement to retained pay is subject to, and indeed only subject to, the principles which follow and which qualify it. Notwithstanding that the entitlement is permanent, it can be removed or reduced by mutual consent on promotion or where the employee seeks a change to his shift pattern. And as pointed out in our case, the respondent's construction makes the phrase "will remain a permanent feature" redundant, just as it is forced to ignore the parts of the admissible documentation setting out the objects of the term as being that it is guaranteed forever, that it will remain for as long as you are employed in that role, etc. If the respondent were right, then, having provided for retained pay to be uplifted by future pay increases, that's the true scope, by the way, of what the respondent refers to as future-proofing the entitlement, and for it to count towards other benefits, the retained pay term would simply have read, retained pay is subject to the following principles. That is a powerful argument supporting the claimant's construction, confirmed by what we know of the surrounding circumstances and documents. Consider the following. Assume that both the retained pay term and the prior documentation, rather than describing the entitlement as remaining permanent, guaranteed for as long as you're employed in the role, etc., had instead described it as guaranteed for 10 years, or guaranteed until age 60. In either case, subject to the same principles as the actual retained pay term. So you would have retained pay is guaranteed for 10 years, subject to the following principles. It can be changed by mutual consent, etc., etc. Would Tesco, in that circumstance, have been able lawfully to remove the entitlement by firing and offering to rehire the workers who had moved after 2 years or 5 years? I don't know what my learned friend's answer to that would be, but I take it that the obvious answer is no. But if that's right, why should what on the face of it is a stronger commitment that it will remain permanent be capable of being construed away as redundant? I note in passing, this term is part of a collective agreement covering 20-odd pages, setting out many contractual entitlements, several of which concern pay. Only once does either of the temporal descriptors will remain or permanent appear? The respondent's response on this issue begins by a reiteration of what I referred to as the insidious mischaracterisation of our case, page 147, para 68. We do not contend that on the natural and ordinary meaning of the term, the entitlement to retained pay must endure beyond the term of the employment contract. The claimants have never argued that. If that had been their case, there would have been no need to injunct their dismissals. They could simply have accepted the new terms and sued for underpayment of wages in either the tribunal or the civil courts. A worker's entitlement to retained pay lasts only as long as it is a term of a contract between that worker and Tesco, just as an employee's entitlement to permanent health or long-term insurance benefits lasts only as long as their contract of employment containing that entitlement continues. In both situations, the question is not whether the entitlement outlives the contract. It doesn't. But can the employer lawfully dismiss in order to deprive the employee of the substance of the ongoing benefits to which they have become entitled? In the PHI cases, by becoming incapacitated for work, in the present case by giving up the right to redundancy payments and moving some distance to a new place of work. And if the answer is no, and it's common ground that it is in the PHI cases, then the only remaining issue is whether in a particular case the employee is entitled to injunctive relief or must wait to claim damages once the breach has occurred. And to trespass on the territory of the implied term issue, as my Lord raised it. The implied term issue, by the way, is simply the obverse side of the same coin, in reality, as the construction issue. The reason why the respondent cannot lawfully dismiss the claimants in order to remove their entitlement to retained pay is the same as the reason why employers cannot lawfully dismiss those with a contractual entitlement to long-term disability benefits in order to deprive them of those benefits. In both cases, the contractual promise is that the benefit will remain, will continue to be paid for the remainder of the employee's working life in that role. So it is no small matter for the guarantee that retained pay will remain a permanent feature of your entitlement to be erased. To do so removes the only and critical temporal dimension of the promise. Without it remaining permanently, retained pay can be removed at any time by fire and rehire, as of course Tesco avers. And whatever permanent might mean precisely in this or other context, it always connotes, as does the word remain, an enduring temporal aspect. When used hyperbolically, as in permanent health insurance, or indeed permanent ink, or indeed permanent injunction, it means lasting for a very long time. Even when used as a statutorily defined term of art, in the phrase permanent employment, to which the respondent draws your attention, it's used to distinguish that employment from one of short fixed duration. So we say the judge was absolutely right to find that the parties had used remain a permanent feature in their normal, natural meaning. And in particular, permanent to connote, as per the OED, continuing or designed to continue or last indefinitely without change, abiding, enduring, lasting, persistent, opposed to temporary. And that is underlined in this particular term by the use of the words will remain as opposed to simply is. The respondent's construction deprives the term of its most important guarantee, that it must last without change, that the entitlement is not temporary. And in that context, its arguments as to the strength in general of arguments from redundancy miss the point. True, in a given case, it may be that different words have been used to refer to the same thing, and or that some of the words are superfluous. They cite 1368 is the relevant page number, the Beaufort Developments case. That case, if one goes to 368 at paragraph 21 was one in which, in the words of Lord Hoffman, sorry, have I given you the right? It's at C. Yeah. So just the line above C, it concerned a contract which has been periodically renegotiated, amended and added to over many years, where it is unreasonable to expect that there will be no redundancies or loose ends. That is far from the present case, where the promise of a permanent entitlement is separate and significant on the wording of the term itself, and the meaning of which is put beyond doubt by the contemporary documents. And the judge was right, the reference is page 235, paragraph 45, at C. The judge was right to reject Tesco's case in part because, as she put it, the entitlement was couched in terms of permanence. If Tesco's argument were correct, she found, that word would be deprived of any meaning and thus superfluous. So, in light of these facts and matters, and applying the principles set out in Arnold and Britton, the meaning of the words retained pay will remain a permanent feature of your contractual entitlement in their documentary, factual and commercial context is straightforwardly as contended for by the claimants. That is the meaning assessed in light of 1, the natural and ordinary meaning of the words remain, will remain, and permanent, continuing or designed to last indefinitely without change, enduring, lasting. It is the meaning which meets the overall purpose of the clause, which was to provide substantive, enduring or lasting protection to those accepting the inducement to forego their redundancy payments that many of their colleagues chose to accept and move to a distant new place of work. And it is the meaning required by the facts and circumstances known by the parties at the time that the agreement was executed, including Tesco's determination to ensure enough workers agreed to move, and the statements made by Tesco or by Tesco and Asdor jointly explaining the term. And it is the meaning consistent with commercial and industrial common sense.
Well, whatever you think it means when you get the contract saying that it's permanent, you don't think it means you've got less job security because you can be sacked for the very reason that you've been given this benefit.
Yes, I am, and I mean this, conscious that it would have been possible to present this appeal in about 10 minutes. The points are not numerous or complicated. However, there is a Court of Appeal decision and a 47-page written argument that I feel it's appropriate to address, but my Lord is right.
Yes, absolutely. I think we're being asked to overturn the Court of Appeal, and obviously Lord Justice Bean gave the judgments, very experienced in this field.
Absolutely, my Lord. So I do apologise, but in a sense I don't apologise for what is to some extent making a fairly simple point somewhat lengthily. We say it would flout industrial or commercial common sense if Tesco's only commitment was to retain pay until it had a sound commercial reason for removing it, to use its own words from page 407, once it had achieved what Tesco had designed it to achieve. A proper construction of the term must give effect to the promise that it will remain a permanent feature of the individual's contractual rights. And the only meaning of that promise is for so long as the affected employees remain at the new distribution centre in their original role, they will have a contractual entitlement to retain pay. Indeed, and
I suppose if you're looking at the background, you might say, well, anybody negotiating a contract of employment does so against a background where it's clearly understood that there is a notice period that can be given and people can be either dismissed or leave by giving that notice period. And that's the background against which all this is going on, which I think feeds into what Lord Justice Bean was saying, that in reality everything is based on the idea that we are within the limits of the contract as commonly understood. What do you say to that argument?
well, my Lord, first a small point. This was not the negotiation of a contract of employment. This was negotiation of a term that became incorporated into a contract of employment, but it was the negotiation of a collective agreement, and therefore, to some extent, one expects and one finds language that is a little more everyday, as it were, than one would find in a contract of employment.
Well, both the union and the employers know how contract of employment
For
works.
sure, my lord, for sure. And just as in the PHI cases, just as in Genvi, just as in the Privy Council case of Ali, there can be, as there was in those cases and there is in this, a contradiction, a tension. You can make a promise, the substance of which can be undermined by another power in the contract. It's not always, by the way, the power to dismiss, but it is in those cases and in this. So, yes, you are making those promises, reaching those agreements, knowing that one of the terms of the contract overall is that the employer has the right to terminate on notice. And, of course, if you were being advised by the best legal advisors, you would actually write into the permanent health insurance scheme term, or the term entitling Mr. Genvi to his redundancy payment, or the term entitling Mr. Ali to the waiver of his fees. You would write in that the dismissal term should be qualified. But that is not the reality industrially and in any of those cases, and it continues not to be the reality. The permanent health insurance benefits, long-term disability benefits continue to be promised without that restriction included. So, yes, my lord is right, there is that tension, there is that contradiction. If there wasn't, we wouldn't be here. But the answer in resolving that contradiction is not simply to take the generalised power to terminate and say it trumps everything, therefore the promise, the substance of the promise, must be ignored. That could have been the answer in all these other cases.
So you are heavily relying on the other cases like Aston and so on to show that these are cases where the contradiction, as you've explained it, is overcome by, if you like, qualifying the employer's right to dismiss with notice.
Well, my lord, without wishing to sound in the slightest arrogant, I start from the position of principle. So even if none of these cases had ever existed, and this was the first case, we say the position of principle is as we ask you to find. We're fortunate enough that over the past several decades there have been various cases that not only limit other express powers, and remember, we are only focusing on one such category. It's absolutely bog standard these days for express powers in employment contracts to be limited by implied qualification if that is necessary to give substance to other promises. If you promise to pay someone a bonus, but you reserve yourself the express power to decide that bonus in your absolute discretion, there is an implied qualification that you can't do it in your absolute discretion. You have to do it not irrationally or capriciously, to take the extreme.
You say it's bog standard, but the courts have been very wary where parties are entitled to contract on the terms that they're free to choose the terms they contract on. You say it's bog standard to imply terms that contradict express terms of the contract. I find that surprising.
My lady, what I said was bog standard was not the general proposition that you can imply terms to contradict express terms.
Oh, that is what you said.
But that if there is a particular promise made, the substance of which can be defeated by the exercise of a general power. And the point I was making is that general power doesn't have to be the power to dismiss. It can be another power granted under the contract. Then what I say, and forgive the colloquialism, I shouldn't have used it, what I say is fairly well accepted law now, is that the courts will imply a qualification to the express power in order to preserve the substance of the particular promise. And I do say that is well-established law. And it is well-established law, including in respect of the express power to terminate. Before I leave the term itself.
Sorry, you're saying in general terms discretions are subject to implied qualifications, or are you making the point simply in relation to the discretion to dismiss without notice?
Well,
are there other examples apart from, I mean, Aston seems bang on point, but are you saying there's another category of cases more widely that you're drawing on, which show these sort of qualifications of what you might call a discretionary power?
We have referred to cases like Hawkillack and others in our written case.
Yeah.
We don't spend much time, in fact I was proposing to spend no time on them today because obviously we're focusing on those cases which specifically deal with what qualifications are appropriate to imply on the general power to terminate as opposed to any other general power. But I was saying, and I hesitantly do maintain, that that is a subcategory of a wider legal principle that if contracting parties, not just employment, we're about to look at a case that has nothing to do with employment. If contracting parties agree a promise and reserve a general power that might, if unqualified, entirely undermine the substance of that promise, the courts will imply a qualification so that it cannot. That is a more general legal principle. But my Lord is right, we're focusing here on the cases where the general power in question is the power to terminate on notice. And before turning to the implied term issue, can I just end by asking the court to reflect on what the substance of the promise actually would be if the respondent is right? Because we say that on the respondent's case, the agreement on retained pay would add almost nothing to the claimant's existing contractual rights. The respondent might just have offered them take redundancy or move to the new distribution centre.
Well, didn't it ensure that the collective bargaining process that everybody was signed up to wouldn't be exercised in a way where the majority could override this minority group of rights? That's the content of it on the respondent's case.
My lady, I understand that, and I was about to say that the only thing it would add on their case is a promise that if a time came when Tesco wanted to reduce their pay, obviously they're not going to want to reduce their own pay.
Well, they're not going to want to, but the majority who vote in favour of collective bargaining exercised by the union might want to, not deliberately to avoid the minority rights, but for whatever majority reasons there might be. That's what it was about from the respondent's perspective. So it doesn't add nothing.
Well, my lady, even in that situation, you have a collective negotiation in which Tesco is suggesting that, let's say for the sake of argument, we increase the pay of those who are on the lower rate and we decrease the pay of those who are on the higher rate. At that point in time, all the retained pay is offering is the retained pay term on the respondent's construction. All it is offering is that Tesco cannot do that by agreement with USDOR. It would have instead to dismiss and offer re-engagement to those on the higher pay at the reduced level of pay. I'm not saying that's nothing, but it's not very much. It's predicated on the premise that Tesco wants to reduce their pay, but it has to dismiss and offer re-engagement on whatever the reduced terms it wants to impose would be, rather than collectively negotiate them with USDOR. That is all, and that, we say, would not have served as an inducement of any materiality. Which takes us to the question of the implied term that to some extent obviously we've rightly canvassed, because it is, as I say, the obverse of the same coin. And we say, with respect to the questions that have been addressed to me thus far, that this ought not to be controversial. Because if the retained pay term does promise an entitlement that will remain as permanent, designed to last indefinitely without change, etc. Along the lines explained by Tesco, it will remain for as long as you're employed in that role, then it follows that the promise is deprived of substantive content if the respondent can dismiss at any time in order to remove the entitlement. Just as, by the way, we accept that if the guarantee of a permanent entitlement to retained pay was superfluous, and the only relevant promise made was that retained pay could not be collectively renegotiated, then there would be no basis for an implication of a restriction on Tesco's right to dismiss. It ought to be that the respondent says if we lose on issue 1, we lose on issue 2, and we say if we lose on issue 1, we lose on issue 2, but it is not so. We would respectfully ask the court to bear in mind that the parties' arguments about whether to imply the term for which we contend must be premised on the claimant's construction of the retained pay term. I know it's obvious, but unfortunately the respondent's case on the question of implication does not always proceed on that premise. The principles governing the implication of implied terms are well established and were not disputed below. The respondent's case reviews those principles at length, citing some 20 authorities. I shall refer to 2 of those. One, because it contains some points of correspondence with the present case on the facts, and the other because it relates also to a collective agreement. First is at page 1970, Equitable Life and Hyman. This concerned policies where policyholders had the option on retirement of taking an annuity either at a guaranteed rate, GAR, guaranteed annuity rate, or the then current rate. But in both cases, the annuity would be increased by what were referred to as bonuses, which was an apportionment of the surplus, the relevant surplus declared by the society. Equitable Life had the absolute power pursuant to Article 65(1) of the Articles of Association to which the policies were subject. That, if you want to see the article, is quoted at page 2014 at G. They had the absolute power to determine the principles and the methods for apportioning those bonuses out of the surplus. Over time, the current annuity rate fell below the guaranteed rate. So instead of being a platform, it became a potential ceiling. And the issue arose whether Equitable Life could declare lower bonuses for those who chose to take their annuity at the guaranteed rate. At 2020-2020, Lord Steyn, with whom the other members of the court agreed, said this at G. It is necessary to distinguish between the processes of interpretation and implication. The purpose of interpretation is to assign to the language of the text the most appropriate meaning which the words can legitimately bear. The language of Article 65 contains no relevant express restriction on the powers of the directors. To this extent, I would uphold the submissions made on behalf of the society. The critical question is whether a relevant restriction may be implied into Article 65. It is certainly not a case in which a term can be implied by law and then over the page. If a term is to be implied, it could only be a term implied from the language of Article 65 read in its particular commercial setting. Such implied terms operate as ad hoc gap fillers. In Luxor, Lord Wright explained this distinction. If I can invite you to skip to the end of the quote. A case like the present is different because what is sought to imply is based on an intention imputed to the parties from their actual circumstances. It is only an individualised term of the second kind which can arguably arise in the present case. Such a term may be imputed to parties. It is not, critically, dependent on proof of an actual intention of the parties. The process, quote, is one of construction of the agreement as a whole in its commercial setting. This principle is sparingly and cautiously used and may never be employed to imply a term in conflict with the express terms of the text. I pause there. The rule that the implied term should not contradict the express term is absolute in the context of the promise. So if the promise is A will give B X, X cannot be changed into Y by implying a term. Where the principle of implication can, albeit sparingly, can be used is where the terms of the text, the terms of the promise itself, do not need clarification or qualification, but there is a separate term of the contract as a whole, the literal exercise or unrestricted exercise of which may undermine the promise. I continue reading. The legal test for the implication of such a term is a standard of strict necessity. This is how I must approach the question whether a term is to be implied into Article 65, that's the general power, which precludes the directors from adopting a principle which has the effect of overriding or undermining the GAR. So the question Lord Steyne poses to himself is, here I have an unrestricted power, unqualified power, can I imply a term to qualify it? The inquiry, he continues, is entirely constructional in nature, proceeding from the express terms of Article 65, viewed against its objective setting. The question is whether the implication is strictly necessary. My lord, final bonuses are not bounty. They are a significant part of the consideration for the premiums paid, and the director's discretions as to the amount and distribution of bonuses are conferred for the benefit of policyholders. In this context, the self-evident commercial object of the inclusion of guaranteed rates in the policy is to protect the policyholder against a fall in market rates by ensuring that if the fall occurs, he will be better off than he would have been with market rates. The choice is given to the policyholder. It cannot be seriously doubted that provision for guaranteed annuity rates was a good selling point in the marketing by the Society of the policies. It's also obvious it would have been a significant attraction for purchasers of the policies. The Society points out that no special charge was made for the inclusion in the policy of GAR provisions. So be it. This factor does not alter the reasonable expectations of the parties. The supposition of the parties must be presumed to have been that the directors would not exercise their discretion in conflict with contractual rights. These are the circumstances in which the directors of the Society resolved upon a differential policy which was designed to deprive the relevant guarantees of any substantial value. In my judgment, an implication precluding the use of the director's discretion in this way is strictly necessary. The implication is essential to give effect to the reasonable expectation of the parties. We trust the points of comparison are evident. The collective agreement providing for retained pay was subject to the remaining terms of the employment contract, including the express power to terminate on notice. The question is whether a relevant restriction should be implied based on an intention imputed to the parties from their actual circumstances. The overarching issue is one of construction of the contract of employment, including the retained pay term as a whole in its commercial setting, which distills in this case to whether the exercise of the power to terminate in order to deprive the claimants of their entitlement to permanent retained pay has the effect of overriding or undermining the entitlement. As in Hyman, we say, the self-evident commercial object of the inclusion of guaranteed permanent retained pay in the contract is to protect the claimants against a fall in this case, wages payable to the workforce generally, by ensuring that if the fall occurs, they will be better off than they would have been with market rates. And as in Hyman, we say it cannot seriously be doubted that the provision for guaranteed rates of pay was a good selling point in the marketing by Tesco of employment at the new distribution centres. We say, like in Hyman, it is also obvious it would have been a significant attraction for the claimants in deciding to forgo their redundancy payments and move. So, as in Hyman, we say, the supposition of the parties must be presumed to have been that Tesco would not exercise its power to terminate in conflict with the claimant's contractual rights to permanent retained pay. Those are the circumstances in which the directors of Tesco resolved upon a decision which was designed to deprive the relevant guarantees of any substantial value. As in Hyman, we say, therefore, an implication precluding the use of Tesco's power to terminate in this way is strictly necessary. The implication is essential to give effect to the reasonable expectations of the parties. The second case is Ali and Christian Salverson. It's relied on by the respondent, page 158, paragraph 96.2, for the proposition that it is in the nature of collective agreements that they should be concise and clear, and that should there be any topic left uncovered by an agreement of that kind, the natural inference is that the topic was omitted advisedly from the terms of the agreement. What might be considered at first blush a surprising observation by Lord Justice Waite, as deployed by the respondent, in fact says something rather different. Page 980. The case involved a collective agreement, my lady, my lords, where employees worked a specified total number of hours per annum. So every employee had to work, I can't remember the number, but let's say 2,000 hours per annum. And that number varied week to week. They could work 20 hours, 30 hours one week, 50, 60 hours the next week. But they were to be paid in equal amounts throughout the year, based on an assumed 40-hour week. The claimant, whose employment ended halfway through the year and who had worked more than an average of 40 hours per week during that first part of the year, sought payment for the actual number of hours he worked. In that context, at C, Lord Justice Waite said this: "The circumstances which are, in my view, crucial to the present case are that this was a collective agreement negotiated across a broad front for a substantial labour force. It represented a carefully negotiated compromise between two potentially conflicting objectives. The desire on the one hand of the employees to have an assured rate of weekly pay spread over a long period to which they would be entitled, regardless of hours actually worked, and the desire on the other hand of the employers to avoid the high cost of paying overtime rates for work done at periods of peak demand. It is in the nature of such an agreement, not all collective agreements, but that particular collective agreement, that it should be concise and clear, so as to be readily understood by all who are concerned to appreciate it. One would expect the parties to such an agreement to set their face against any attempt to legislate for every possible contingency. Should there be any topic left uncovered by an agreement of that kind, again, not all collective agreements, the natural inference is not that there has been an omission so obvious as to require judicial correction, but rather that the topic was omitted advisedly from the terms of the agreement, on the ground that it was seen as too controversial or too complicated, please note these words, to justify any variation of the main terms of the agreement to take account of it. I note in passing, of course, that the position of an employee who left partway through the year was as likely to be to their benefit as to their disbenefit.
It's a sort of rough with the smooth type of reasoning, isn't it?
You don't repay money if you've worked fewer than 40 hours a week on average. You don't get any more if you've worked more.
It's better to have a simple, clear rule than that overcomplicated structure, even if sometimes it's in your favour and sometimes it's against.
Now, in the paragraph I referred to from the respondent's written case, not only does it omit the contextual reference to explain what the court meant by such an agreement and an agreement of that kind, it inexplicably omits to quote the words of the main terms of the agreement, and thus changes the sense of the point made, which is that where you have a contract or collective agreement which provides for a compromise between two competing objectives, the terms of that agreement should be taken to have provided for all aspects of the compromise which the parties intended should be covered, and therefore no additional provisions should be implied into that agreement. The present case is entirely different. There is, ex hypothesi, no issue as to the terms of the collective agreement dealing with retained pay, which are admirably comprehensive. The issue is whether, given those terms, it is necessary to imply a qualification to an entirely separate term of the employment contract, the right dismiss on notice, which without such qualification could operate to undermine the carefully negotiated compromise recorded in the collective agreement. The question is always the same. Is it necessary on the officious bystander or the business efficacy tests to imply a qualification to one express power in the contract in order to ensure that it is not exercised, in the words of Lord Steyn, in a way designed to deprive the relevant guarantee of any substantial value? And, as a significant number of cases have now determined, that more general principle, we say, applies no less when the express power is the power to terminate on notice than in other situations. We've referred to the relevant authorities in our written case. For present purposes, I invite the court only to one of those cited by both courts below, my lady's judgment in Awan, which considered the earlier cases. Picking it up, if I may, at page 1153.
I'm sorry, the page again?
1153, my lord.
Thank you.
At paragraph 46 at the top of the page, having reviewed the earlier cases, my lady said this: these cases support the argument that where the employer has made a contractual promise to cater for long-term incapacity for work by conferring valuable disability or PHI benefits on employees according to an established scheme, the whole purpose of the scheme would be defeated if the employer could bring to an end such entitlements by dismissing employees when they became unfit for work and have accrued or are accruing benefits. That's the yardstick, same in this case as in Hyman, whether the purpose of the scheme conferring the entitlement to permanent retained pay would be defeated if Tesco could bring it to an end by dismissing the claimants once they'd moved to the new distribution centre and were consequently in receipt of retained pay whenever Tesco decided it had achieved its commercial objective in securing the moves. The lady makes the point again at paragraph 49, but can I turn to paragraph 51? The next page, the express power to terminate is in general terms. It does not expressly deal with incapacity, as the clause in Aspen did, and it does not expressly reserve a right to dismiss without cause, as in Reader and Flag. But the contract also includes an express term that disability benefits, once payable, will continue until death, retirement, or return to work. There's no reference to dismissal for incapacity in Clause 6 or Section G of the booklet. Those are the provisions that set out the entitlement to long-term benefits. If the respondent was free as a consequence of Clause 11, that's the general right to dismiss on notice, to terminate the contract on notice while entitlement to disability benefits was ongoing, the unequivocal entitlement in Clause 6 would be deprived of its content. In effect, Clause 6 would read, should you be absent from and unable to work due to sickness or injury for a continuous period of 26 weeks or more, you will receive a disability income of 2/3 of your base annual salary. The income will commence 26 weeks after the start of your absence. It will continue until the earlier date of your return to work, death, retirement, or dismissal for incapacity. I might add, presumably, or dismissal because you're in receipt of benefits. So rewritten, the entitlement ceases to be an entitlement at all. There are no circumstances in which the respondent would be contractually obliged to pay disability benefits in the long term if it preferred not to do so. The terms are inherently contradictory. Either the claimant had a meaningful entitlement to, I add the words, long-term disability benefits until his return to work, death, or retirement, or the respondent had an unfettered right to terminate his contract on notice at any time, even for incapacity, but not both. The contract has the effect on this reading of giving with one hand and taking away with the other. That is the situation here. Tesco's express power to terminate is in general terms and does not deal with the situation where an employee is in receipt of permanent retained pay. But it also contains, on the claimant's construction, which is the only relevant construction for present purposes, a permanent, long-term entitlement to retain pay for those who moved to the new distribution centres, which does not mention dismissal. If the respondent were able, while that entitlement was ongoing, to rely on its general right to dismiss in order to remove it, the entitlement to permanent retained pay would be deprived of its content. In effect, it would read the retained pay term, the permanent entitlement to retained pay will commence when you move to the new distribution centre and will remain until retirement, your circumstances change, or the exercise of Tesco's unfettered right to terminate at any time, even because you are in receipt of retained pay. The exact analogue. I would gratefully adopt my lady's phrasing, therefore. So rewritten, the entitlement ceases to be an entitlement at all. There are no circumstances in which Tesco would be contractually obliged to pay retained pay in the long term if it preferred not to do so. The terms are inherently contradictory. Either the claimants have a meaningful permanent entitlement to retained pay, that's the construction that we are assuming, or the respondent has an unfettered right to terminate their contracts on notice at any time, even in order to avoid honouring the entitlement to retained pay, but not both. And that is the basis of my lady's conclusion over the page at paragraph 55, picking it up about 4 lines into that paragraph, that the entitlement to long-term disability benefits could only work if the employees eligible to receive such benefits remained in employment for the duration of their incapacity. The contract of employment is inherently contradictory. It seems to me that on a proper construction of the contract, it is contrary to the functioning of the long-term disability plan and to its purpose to permit the respondent to exercise the contractual power to dismiss so as to deny the claimant the very benefits which the scheme envisages will be paid. In my judgment, a term can be implied, whether on the officious bystander or the business efficacy tests of implied contractual incorporation, that once the employee has become entitled to payment of disability income due under the long-term disability plan, the employer will not dismiss him on the grounds of his continuing incapacity to work. That term is capable of clear expression, reasonable in the particular circumstances, and operates to limit rather than contradict the express contractual right to terminate on notice, by preventing the exercise of that right in circumstances where it would frustrate altogether the entitlement to long-term disability benefits expressly provided for by the contract. To imply a term in the present case that once the employee has moved to the new distribution centre and become entitled to permanent, that is long-term retained pay, the respondent will not dismiss him on the grounds of his continuing receipt of that entitlement is, we say, equally appropriate on the officious bystander or the business efficacy tests. It is equally capable of clear expression, reasonable in the particular circumstances, and operates to limit rather than contradict the express contractual right to terminate on notice by preventing the exercise of that right in circumstances where it would frustrate the entitlement to permanent long-term retained pay expressly provided for by the contract. With that in mind, could I invite the court, please, to turn to page 156 within the respondent's case and paragraph 92. The criticisms the respondent makes there of the judge's decision would be equally valid in a case like our one. The employer has an express unqualified right to terminate on notice in our one. The implied term imposes a serious and perpetual constraint on the employer's ability to manage its business. My learned friends use the word perpetual, I take it, in the same loose but clearly understandable way that the parties who agreed the retained pay term used the word permanent. And the implication of the term reverses the ordinary principle that a person who has a contractual right is entitled to exercise it for any reason at all. As made clear in all of the permanent health insurance or long-term disability cases from Aspden to Awan, as also in Genvy and in the Privy Council case of Ali, the unlawfulness arises from and is restricted precisely to the reason or motive for the exercise of the right to terminate. Termination for any other reason, gross misconduct, redundancy, etc., is not unlawful. What matters, as my lady put it, is whether the dismissal is on the grounds of the employee's receipt of the relevant permanent benefit or on the grounds of the circumstances triggering that entitlement. There are 2 decisions of the Court of Appeal, Brompton and Briscoe, which also concluded that an employer was not permitted to exercise its right to terminate claimant's employment in order to deprive him of his entitlement to permanent or long-term disability benefits, but which also confirmed that termination for an unrelated reason would remain lawful, and we've cited the relevant passages in our written case. At 168, page 168, apologies, at paragraph 124 of the respondent's case, it attempts to deny the analogy of those cases to the present one. That attempt fails. First, the fact that the claimants did not become unfit for work does not negate the analogy, that is, the essence of an analogy, a comparison of different factual situations with similar features. The claimants in Aspen, Awan, etc. were promised that if a certain factual circumstance happened, they would become entitled to permanent or long-term benefits, and the permanent or long-term entitlement would be deprived of substance if once that event occurred, the employer could lawfully dismiss to disentitle them to those benefits. The claimants in the present case were promised that if they gave up their right to a £7,000 redundancy payment and moved to a new distribution centre 40 miles away, they would be entitled to the benefit of permanent retained pay. And that permanent entitlement would also be deprived of substance if, after they moved, the respondent could lawfully dismiss to disentitle them to those benefits. The only difference of note is that whereas in the PHI cases, as in Genvi, the employee might never qualify for the relevant benefit, might never qualify for the long-term sickness benefits, and if they did, it might be years later. In the present case, the employees who did accept the retained pay terms knew that their entitlement to retained pay would be triggered shortly, and it did in fact arise when they moved, in some cases, as I understand it, many months later, but within a relatively short period of time. Going back to the respondent's case, this 124.2, there is only no contradiction between the retained pay term and the express term regarding termination on the respondent's construction of the former. On the claimant's construction, the contradiction is no less self-evident than in the permanent health insurance cases. 124.3. The right to permanent retained pay does take effect after the move for so long as the claimant's contracts remain afoot, just as the right to permanent health insurance takes effect once the employee becomes incapacitated for so long as their contract remains afoot. The fact that it might be said in either case that thereby the right is not entirely illusory says nothing about the necessity to imply a term so that the employer cannot negate it at will when it chooses. In PHI cases too, the unlawful dismissal might take place years after the initial entitlement was triggered. 124.4 is simply an assertion that there is no basis to imply a term, and 124.5, which may include a typographical error, incapacity for retained pay, is in any event a further mischaracterization of the claimant's case. The claimants do not say that Tesco must continue actively to employ them even if they do not wish to do so, only that they may not lawfully dismiss them specifically to deprive them of their entitlement to permanent retained pay, just as in the PHI cases. And it may be that the respondent is using the word actively to imply that, unlike in the PHI cases, the claimants remain at work, and if the submission is that that would be a striking outcome, then for reasons that we will develop later by reference to authority, we disagree. Foreshadowing those later submissions very briefly, this is not a case where the respondent would be required to continue employing workers in whose competence or good conduct it had lost confidence. The respondent could lawfully terminate the claimant's employment for misconduct, incapability, redundancy, indeed any reason other than to deprive them of the permanent retained pay it had guaranteed them. And finally, on the significance of the line of authority that began with Aspen, and there have been subsequent cases, but for the present purpose ends with Awan, I turn briefly to the cases cited at 165, in the respondent's case, at paragraph 116. The unreported case of Jones concerned a claimant who had no contractual entitlement to long-term sickness benefits, but rather a fairly standard time-limited entitlement to sick pay, which was itself subject to an express term permitting the employer to terminate before the full entitlement had been exhausted. We do not understand its relevance. Reliance on the unreported decision of the Sheriff's Court in Blake is also confusing. In the main part of the judgment, it was taken as read that the employer would have been in breach of contract if it had dismissed the pursuer when he was in receipt of PHI benefits. The different issue that arose in that case was whether the employer could lawfully dismiss when the pursuer's receipt of those benefits had been stopped by the insurer. The sheriff decided it could, on the particular facts where the pursuer had not asked his employer to sue the insurer and had offered no indemnity for its costs. True, in the final paragraphs of that judgment, the sheriff suggests obiter that all of the PHI cases decided before Johnson and Unisys, as well as Genvy, may well have been wrongly decided. The analysis is, with respect, flawed, but in any event, the respondent does not invite this court to follow the learned sheriff down that path. Finally,
there's a curious rule of practice in a house. You're not allowed to cite sheriff court judgments. But for some reason, the House of Lords and the Supreme Court have never applied the same rule.
Well, my lord, I had thought, though I don't mean to tease my learned friends unnecessarily, that we weren't supposed to be reciting unreported cases, except in very exceptional circumstances, none of which apply to these, but I don't take procedural points unless they're also, as it were, substantive. They finally refer to a case of Lloyd, which was in fact about largely rights to holiday pay when off sick. But insofar as it has any point of correspondence, it's so far from the facts of cases like Aston and Owen, it is again hard to see why it has been cited. First, the contract, which had, incidentally, an entire agreement clause, made no reference to PHI benefits. It was therefore unsurprisingly held that the claimant had no contractual right to those benefits. Secondly, after the claimant did become ill and began receiving payments under a policy which his employer had taken out, he was fully paid out until retirement age under that policy and therefore suffered no loss when his employment was terminated 6 months prior to that retirement date. Finally, there was an express term of the contract entitling the employer to terminate within a stipulated period after he became sick. The only plausibly relevant part of the judgment is at page 2659. Paragraph 58, where the EAT suggested that if it had been appropriate to imply a term, which it obviously wasn't on the facts of that case, they would have adopted the approach in Briscoe and Lubrizol that the qualification on the right to dismiss should permit termination for reasonable and proper cause, noting that they had heard no argument on the point and it formed no part of the reasons for their decision. In fact, in passing, and this may be of some significance when one discusses the terms of any injunction, the formulations suggested by Lord Justice Potter and Lord Justice Ward in Briscoe were a little more nuanced than that summary. They focused on the unlawfulness of terminating for a cause or as a means to deprive the employee of his ongoing entitlement. We've quoted the material parts of those judgments at paragraph 83 of our written case. There is no analysis by the respondent of these three decisions. They do nothing to assist its argument. In Genvy, where the entitlement was to a redundancy payment, Mr. Justice Elias's analysis led to the same conclusion insofar as material as in the PHI cases, namely that once the employee had prima facie qualified under the scheme, the employer could not rely on its unqualified right to dismiss in order to deprive him of that entitlement. The ratio is stated at page 2479. At paragraph 28, towards the bottom of the page, it follows that in this case, the defendant employer was in breach of contract in dismissing the claimant for the reason it did. The contract was not lawfully terminated simply by giving the requisite notice, because the power to dismiss on notice for this reason was not a contractual option. And the Privy Council came to a similar conclusion in the Ali case. Again, we've cited the material parts of the board's judgments at paragraphs 97 and following of our written case.
Sorry, I didn't hear the last.
Sorry,
97 and?
97 to 100 of our
97
case.
to 100, and that's in Ali.
Sorry, that's our case.
That's your case.
97 to 100, citing the relevant passages from
Thank you.
Ali. Apologies. My Lord, these have likely been overlong submissions to address the respondent's arguments on the law. I now turn to its arguments on applying the law in the present case. At page 155, paragraph 89 of the respondent's written case, it wrongly suggests that our case is that the implication of a term is required only to address an inconsistency which arises where an affected employee is dismissed and agrees to be re-engaged. No, that is not our case. The inconsistency is between the substantive content of the entitlement to permanent retained pay as construed by the claimants and the right of Tesco to dismiss at any time in order to remove or reduce that entitlement. It would be just as unlawful if the dismissed employee sought alternative employment as if they accepted the offer of re-engagement. It would be just as unlawful if there was no offer of re-engagement. If Tesco simply said, we're going to dismiss all of you and we're going to recruit people at a lower rate of pay, they probably would lawfully have had to go on to say, and you can apply for those jobs. But as a matter of practice, because of the statutory unfair dismissal regime, you always do have to offer the employees the lower rate of pay rather than go outside, because otherwise the dismissals will, in practice, automatically be unfair. But as a matter of contract, it makes absolutely no difference.
The mischief is dismissing for the purpose of depriving them of the retained pay.
Thank you, Millard. Yes, that is our case. And at paragraph 104 on page 162 of its written case, the respondent relies on the conclusion of Lord Justice B in these words: if the officious bystander had asked whether the retained pay employees had the right to remain in post until the site closed for the rest of their lives, the claimants might have answered, of course, but the company would certainly not have done so. Well, I imagine neither party would have answered yes to that question. But with respect to the learned Lord Justice, that is clearly not the right question. And as was importantly confirmed in several cases, including the fourth relevant principle of which includes it is vital to formulate the question to be posed by the officious bystander with the utmost care. The right question, assuming the claimant's construction of the retained pay term is correct, is something along these lines. Is the permanent entitlement to retained pay offered to persuade affected employees to move their place of work and explained to them as an entitlement which remains for as long as you are employed by Tesco in your current role, consistent with the right of Tesco to fire and offer to rehire them as soon as it was in its commercial interest to do so in order to remove that entitlement? Now, if the parties had been posed that question at the legally relevant point in time when the term was agreed, then objectively their answer would have been, of course not.
Quite a long question. Could you rephrase it or repeat it?
My Lord is right. I apologise. Let me remove some of the wording
the middle
from
part was
the
probably
question.
superfluous.
You could just say, can you exercise, can you dismiss people in order to remove the right to retain pay? I mean,
Yes, I suppose it's difficult to improve on that. I was simply incorporating into the question what that right was. But if we proceed, as obviously by Lord Legate's question does proceed, on the basis that we know what the right to retain pay was, it was long-term, permanent, for as long as you're employed in the current role, then yes, it does distill just to that. Is the permanent entitlement to retained pay consistent with the right of Tesco to fire and offer to rehire them as soon as it was in its commercial interest to do so in order to remove that entitlement? And on the claimant's construction, bluntly, there can be no dispute that is the right question. I suppose in theory there could be a dispute as to what the answer is, but I'll leave that for my learned friends to address. The concession of one of the claimants recorded at page 162, paragraph 105 of my learned friend's written case, that there was a range of factors which might have caused him to lose his job, that he had no guarantee of employment till retirement age, due to the pandemic now and stuff, people losing their jobs, likewise misses the point. It was a concession rightly made. It would have been made by any of the claimants in the PHI cases. And indeed, it was the ratio of the decision in favour of the employer in Hill, it's the decision of the outer house, who lawfully dismissed Mr. Hill because he was redundant. People were losing their jobs, even though he would shortly have qualified for long-term sickness benefits. I'll come back to the case so you can see that in its proper context later. The respondent offers other formulations of the question the officious bystander might ask in the following paragraphs, which we say also avoid addressing the real issue. And indeed, the premise of them, certainly the one at paragraph 106, seems to be that the respondent has succeeded on the contractual construction issue. Of course, if will remain permanent means nothing in the retained paid term more than not subject to collective renegotiation, then a query by the officious bystander whether it placed an everlasting fetter on Tesco's right to terminate and on its judgment how best to operate its business would have elicited a no from Tesco. Again, that is not the right question, and its implicit premise is wrong. And we say that the respondent gives the game away more transparently in the next paragraph, 108. There is no need, it argues, for a term to be implied to give business efficacy to the agreement to pay permanent retained pay, because permanent means no more than for so long as their contracts continue. Now, that interpretation of the term on its face is untenable. All contractual entitlements last for so long as the contract in which they are recorded continues, without a need for them to be described as remaining permanent. But even if that were, in theory, a plausible interpretation of remaining permanent, let alone remaining for as long as you're employed in that role, that ship has sailed. For present purposes, the respondent must accept that will remain permanent means something entirely different. And as to the suggestion at paragraph 109 that the implied term contended for by the claimants would make their contracts unworkable, first, it is based on a single unlikely hypothetical scenario that Tesco might choose to close down a particular distribution centre because some of the workers there were in receipt of retained pay. Secondly, it inaccurately extrapolates from a submission that we made, page 110, paragraph 105C of our written case, which deals with a different scenario, the one hypothesised by the Court of Appeal that we discussed a little earlier, that Tesco selected for redundancy from among the workers employed at a single distribution centre those in receipt of retained pay. And it conveniently ignores, despite the point having been made in our written case, that precisely the same argument could be made in a case where the entitlement was not to permanent retained pay but to permanent sickness benefits. I interpose to observe that it's difficult to know how sincere the respondent's concession is that cases like Aston and Owen were rightly decided. Many of its arguments as to why this court should not imply a term to restrict it from dismissing the claimants in order to deprive them of their entitlement to permanent retained pay would apply with just as much or as little force in those cases, as indeed they would have applied in the Privy Council case of Ali. And as the court has seen, the respondent seems to place some reliance on a judgment from the Sheriff's Court which suggests that those PHI cases were wrongly decided. Returning to...
Well, Lord Justice Bean came to the same view, didn't he? He was saying there's nothing wrong with Aston, but I don't presumably think it's applicable in this case.
Sorry, I didn't hear the last bit, my lord.
But presumably his view was that it was, for some reason, not applicable in this case.
My lord, the reasoning of Lord Justice Bean and the reasoning of my learned friends obviously overlaps, but it is not the same. And several of the arguments that my learned friends raise in their written case do not appear on the face of the judgments of the Court of Appeal. But if
Lord Justice Bean's problem seems to be he didn't think it could be clearly formulated, the term.
That was one, certainly, and that obviously I will be addressing. That was certainly one of the grounds. But I mean, I don't resile from the concession that Lord Justice Bean was against the claimants on every point. He didn't think that the right way to construe the term, even considering the relevant contractual and pre-contractual admissible documentation, was, as the claimant said, in which case the claimants do lose. He didn't think that even if it was, although he doesn't really follow through with respect in his reasoning, but he says that he didn't think even if it was right that you could imply a term, and partly for the reason that my Lord Legate has just said, he didn't think that it would be right to imply the term contended for, certainly to injunct in the way that the judge did injunct, because the term and the corresponding injunction were too uncertain. So I have to accept the Court of Appeal was against us at every stage. At the moment, I'm focusing only on that second stage. If we're right about the proper construction, is it right to imply a term? And what I'm saying is that the respondent's written case goes rather further, makes more arguments and different arguments to those relied on by the Court of Appeal. And what I'm saying is, and it's, I suppose you would be entitled to dismiss it as something of a jury point, but many of those arguments would imply, though of course they do not state any more than Lord Justice Bean does, but would imply that the cases of Aspden and Briscoe, Hawan, Gemby were wrongly decided, because they would apply to undermine the ratio of those cases in precisely the same way as they are said to apply to undermine the claimant's case in the present litigation.
I mean, actually, although he was against you on the point, Lord Justice Bean, that is, said that the PHI cases were right.
He did. I mean, they give with one hand, they take with the other. They say they're right, then they make arguments inconsistent with them, and then they rely on a case that says they're wrong. All I'm saying is, I'll wait, obviously, to hear how they put it, but I would humbly ask the court to put them to election, not allow them to ride both horses in different directions. Returning to the particular hypothesis of the redundancy situation, and I said I would come back to Hill, and I will do so as soon as I have unlocked my computer. Page 2350. The court had to consider an actual redundancy case. And having held at paragraph 20 towards the bottom of the first column, that the employer could not, fourth line, solely with a view to relieving himself of the obligation to make such payment by dismissal, bring the employee's contract to an end. So it's a case entirely consistent with the claimant's case here. Lord Hamilton then articulated the determining factor within paragraph 22, second column, as being that the implied term had to be formulated such that it did not restrict the employer when the claimant's selection for redundancy, we're picking it up at the end of the 1, 2, 3, 4, 5, 6, 7th line, I think, selection for redundancy was genuine and with cause, having regard to the whole circumstances then obtaining, because if it were, that would, as the court found later down in that paragraph, be grossly disadvantageous. I'm picking it out 1, 2, 3, 4, 5, 6, 7, 8, 9 lines from the bottom, I think, possibly 8, sorry. There's a line beginning grossly disadvantageous, I'm sorry. Because otherwise it would be grossly disadvantageous to employees who happened to be well as against employees who happened to be ill at the material time. In other words, and we absolutely accept the rightness of this proposition, if an employer wishes to make a commercial decision that would, absent the entitlement of some of its employees to long-term permanent benefits, whether they be sickness benefits or retained pay, if an employer wants to make a commercial decision that, absent that consideration, would see a group of employees being made redundant, then those in receipt of long-term sickness benefits, those in receipt of permanent retained pay, are in no better position than those who are not. They don't have any greater right to retain their employment where the reason for termination is redundancy or misconduct or capability or the automation of Tesco's distribution centre, which would be presumably a redundancy situation. So if, as the respondent argues, the fact that the implied term might in theory prove difficult for Tesco in the specific unlikely situation it posits is fatal, as it says, to our case, it would have been equally fatal in Aspden, Awan, Genvi and Ali. Finally, as regards their hypothetical scenario, the claimants say that in a situation where Tesco closes down a distribution centre and dismisses some of the affected employees as redundant along with their colleagues, that would not be in breach of the implied term. The reason for the dismissals would be the closure of the distribution centre, not in order to remove from the claimants their entitlement to retained pay. And the related arguments on the supposed uncertainty of the implied term at paragraphs 113 and 14 of the respondent's case are equally invalid. The term that the respondent should not be able lawfully to dismiss the claimants because they are in receipt of retained pay or for the purpose of removing or reducing their entitlement, those formulations amount to the same thing, is not materially uncertain. And its equivalent was not deemed unacceptably uncertain in cases like Genvi or Awan. Indeed, in Awan, as the court has read, my lady characterised the implication of such a term that the employer would not dismiss the claimant on grounds of his incapacity to work as one capable of clear expression. My lady, my lords, it's been a tortuous road, but the proper destination we submit is obvious. Where an employee has a contractual entitlement to a benefit which accrues in a particular circumstance, being unable to work through ill health, as in Awan, there being a redundancy situation, as in Genvi, surrendering a redundancy payment and moving to a new distribution centre, as in the present case, the courts imply a limited restriction on the exercise by the employer of its general right to terminate, such that it cannot dismiss the employee because they have become entitled to that benefit or in order to deprive them of that benefit. Because without such restriction, the employer is able to defeat the substance of its obligation to provide that benefit. And where the entitlement is to receive the benefit permanently or long-term the remainder of the employee's working life, as in cases like Awan and ex hypothesi the present case, then that restriction applies for so long as the employee continues to be entitled to receive the benefit. I turn to remedy. First, a few words on the litigation history.
So, just to be absolutely clear, your apparent slight reformulation of the implied term as against what was said at first instance, you say, in substance, it makes no difference. You're happy to go with what Mrs. Justice Ellenbogen advised.
Absolutely.
You think there's a more, if you like, simple way of saying exactly the same thing?
Yes, I was this time trying, as Lord Legate did previously, to use the fewest words possible. But they do amount in substance to the same thing, yes. As I say, a few words on the litigation history in relation to remedy. It was Tesco's position until oral submissions in the Court of Appeal that this case fell within the Johnson exclusion zone, and therefore that damages were not available at common law. That's recorded in the High Court judgment, and it is in the permission to appeal documents that were served by Tesco. In all events, it was in that context only, as is evident on the face of the High Court judgment, that arguments as to the inadequacy of damages were canvassed in front of the judge. The respondent did not, at trial, oppose the granting of an injunction in principle. Indeed, they cooperated with the judge in suggesting refinements to the words to be used. My Lady, my Lords, the parties' written cases on whether the judge was entitled to grant the claimant's injunctive relief are somewhat like ships passing in the night. The respondent makes three arguments. To be fair, it makes them more than once in each case. The first, the injunction amounts to specific performance, which will not generally be granted where damages are an adequate remedy. The second, anyway, an injunction should not be granted to compel the continuation of an employment contract. And the third, the terms of the injunction were not sufficiently precise. And to be fair to them, they would say could not be formulated so as to be sufficiently precise. We say those arguments are bad, and the first two were not raised below. However, the initial point I'm making is that the respondent's case does not engage properly with the statements of principle, or indeed most of the case law, relied on by the claimants in their written case. I therefore summarise those again and await the respondent's oral response to discover if they're accepted. First, the power of the High Court to grant a final injunction is by statute available in all cases in which it appears to the court to be just and convenient. Second, the decision of a judge whether to grant injunctive relief is a paradigm exercise of judicial discretion with which an appellate court should be slow to interfere absent clear evidence of an error of law. We've cited the relevant authorities in that case. Third, per Lord Cairns in Doherty and Allman, if parties to a contract for valuable consideration contract that a particular thing shall not be done, an injunction does nothing more than sanction that which is already the contract between the parties, in which event questions of damage or of injury are not engaged. See also, because it was strictly obiter in that case, Doherty and Allman, the cases of Hampstead and Suburban Properties versus Diomedes, per Mr. Justice McGarry, and the judgments of both Lord Justice Elias and Lord Justice Jackson in Araki and Fallon, the Racehorse and Derby case. Fourth, the availability of an injunction to prevent a dismissal in breach of contract has been approved in principle by this court in Edwards, by both Lord Dyson and Lord Kerr, the other members of the court agreeing with those judgments, though not referring to that point, it is right to say. Further, a permanent injunction has been granted by the High Court to restrain a dismissal in breach of contract, both in Jones and Gwent and in Chabra, and moreover was approved.
And in what, sorry?
Chabra, C-H-A-B-R-A, the doctor's case,
Yeah.
and was approved prospectively by the Court of Appeal in the case of Powell and Brent.
I'm sorry, what was approved?
That a permanent injunction, permanent as opposed to interim, my lord, is the point, to restrain a dismissal in breach of contract. Injunctions to restrain dismissals in breach of contract at the interim stage are, I won't say common.
Are those all cases involving public bodies that had very complex dismissal procedures, and the dismissal was in breach of those, or was purporting to be in breach of those procedures?
Not all of them, no.
Not all of them.
But some of them, yes.
Powell and Jones.
Chabra definitely was.
Yep.
Powell and Brent was not. Hill and Parsons, which we'll come to, was not. My lords, my lady, I take together the respondents' arguments that the injunction amounts to specific performance, which shouldn't be granted if damages are an adequate remedy.
Well, I mean, I suppose one might say it's a big point, but the background to the rule against specifically enforcing employment contracts is pretty far removed from employers like Tesco.
My lord, you may have shortened my submissions by half from now to the end, but
well,
yes.
not necessarily. That's, I'm one voice of five.
Yeah. Look, I make no bones about it. We say the respondent's analysis, and there isn't actually much analysis, the respondent's citation of textbook authority and case law does not engage with the issue my lord has just raised. It does not engage with the rationale for the general rule or the rationale for the exceptions to the general rule, and it does not engage with whether the present case is consistent with the former or the latter. But
you would accept that it's a general rule, I say general, that specific performance, we know as a matter of statute, can't be given against an employee, but equally, as a general rule, cannot be ordered against an employer, even in situations that might be regarded as not somebody just with an individual in mind, but also in relation to large workforces. Or do you not accept that?
I do accept that, but can I just unpick, if I may, the words general rule? It is a general rule in the sense that it is a very long-established rule. It has been referred to as a general rule or an ordinary rule or a rule that applies in the ordinary case. But the reason it is general is because general connotes, as applied in the large majority of cases, and it certainly is, because the large majority of cases decided from the 1800s onwards have concerned first relationships of master and servant that are personal. That is no longer the case, in certain Tesco's case anyway. And secondly, because fortunately for us, not all, but in nearly all the cases, where an employer has wanted to rid itself of an employee, it has been precisely because it has lost confidence in the integrity, loyalty, or capability of that employee. So both general in the sense because it used to be that master and servant contracts were considered, and probably were, largely personal, and general in the sense that the reason for dismissal is generally a loss of confidence in some sense. So yes, a general rule in both those senses, but not in any wider sense, as we will see.
So you're founding what you might say is an exceptional circumstance on the Hill and Parsons, Powell and London Borough Brent idea that where there is no loss of trust and confidence by the employer in the employee, then indirect specific performance by an injunction is permissible. Is that the kernel of
It's permissible, and not only is it permissible, it has been said in terms to be permissible in all of the cases that we will refer to and in the two textbooks that my learned friends cite. This is not a novel proposition I'm advancing.
Can I just, before I lose the point, I think you earlier said this is all about permanent injunctions. I mean, my understanding is that almost all of the cases that you're talking about are actually interim injunctions. I mean, it's been an objection raised whether you're talking about an interim or a permanent injunction, I think.
I am talking about a final or permanent injunction, and I will, if my Lord will permit me, I will come in due course to why that is not a common situation, in that the courts have to determine whether final injunctions should be granted in such cases, and B, whether and to what extent different principles would apply if the court is considering whether to grant a final injunction as opposed to grant an interim injunction. But spoiler alert.
I think my only point is that all the cases that you've talked about were, I think, interim injunction cases. It's not as if, interim injunction cases, there's no problem. The rule against indirect specific performance is being applied equally to temporary indirect specific performance, i.e. interim injunction, as well as to permanent, I believe.
I mean, 2 points, if I may, my Lord. First, not all the cases I've referred to have been interim injunctions. I've already mentioned 2 that were final injunctions and 1 where the court expressly adverted to what would happen at trial, Powell and Brent. This is a foreshadow, but Powell and Brent was a case where the interim position was considered by a judge a lot more evidence than became available to the Court of Appeal, and the Court of Appeal held that whilst the judge was perfectly entitled on the evidence before him to reach the conclusion he did, in light of what was effectively now an agreed facts case, the Court of Appeal would grant the injunction, and they say in terms, because it's likely to be granted at trial. So I was proposing to address, as I say...
Could you give us the reference for that?
The Powell and Brent reference?
Yes.
My Lord, I can, though I was proposing to take the court to the case, but let me
All right, I'll wait then to come to it.
If my Lord doesn't mind, thank you. Because I think it is important to actually look at the way they express that conclusion. So I was going to take together the first 2 of the respondents' arguments that I identified, namely that the injunction does amount to indirect specific performance and that should not be granted in respect of employment contracts. The cause of action in this case is, ex hypothesi, dismissing the claimants in breach of an implied promise not to terminate their employment in order to remove their retained pay. An injunction to restrain those dismissals restrains, therefore, the breach of a negative promise. It does not in any substantive sense amount to an order for specific performance because the respondent wishes to continue employing the claimants. For the general proposition in relation to negative covenants, I think both parties rely on a passage in Chitty at 3802.
Sorry, the page reference?
3802, my lady. 3802, paragraph 31075. Under the heading negative contracts. Where a contract is negative in nature or contains an express negative stipulation, we would interpose, or an implied negative stipulation, breach of it may be restrained by injunction. In such cases, an injunction is normally granted as a matter of course, so that the fact that damages would be an adequate remedy is not generally a relevant consideration where the injunction restrains the breach of a negative covenant. So we start from the proposition that there is nothing in the slightest objectionable in the grant of an injunction in this case therefore, unless the case law, and I understand this is what some of the court has started to explore with me, unless the case law in respect of contracts of personal service provides that objection. And as to the latter, the respondent cites, although doesn't quote from, both Chitty and Snell's equity. The relevant parts of Chitty begin at 3777, 3,777.
Just before you move on from that, I mean, the extract we've got at page 3809, you then turn over to no indirect specific performance.
Yeah, I agree, my lord.
That's what we're really looking at here. We're not dealing with the normal position that a prohibitory injunction is the standard remedy for a negative covenant, because we're dealing with breach of a negative stipulation in a contract for personal services, which includes contract of employment, will not, however, etc.
My lord, I entirely accept that those are the... I was about to cite the relevant parts of Chitty in relation to indirect specific performance of employment contracts. But my lord is entirely right. That is the question. I'm simply laying the ground, as it were, that unless there is an objectionable order indirectly to compel specific performance of a personal contract of service, there should be no objection to this injunction. But I agree, the unless needs to be explored. And at 3777, the, as it were, general position is articulated at the bottom of the page, 31033. Specific performance of certain types of contracts may be refused, even if damages are an inadequate remedy. In these cases, the reason for refusing specific relief is not that it is unnecessary, but that it may be undesirable to grant it or impracticable to enforce it. So that's the rationale of the general rule. It has long been settled that a contract of personal service or employment will not, as a general rule, be specifically enforced at the suit of either party. Then over the page, at paragraph 034, the reason why specific enforcement is not available against an employee, as my Lord Burroughs noted, is that such an order is thought to interfere unduly with his personal liberty, 5 lines down. Conversely, an employer could not be forced to employ. It was thought to be difficult or undesirable to enforce the continuance of a personal relationship between unwilling parties. So that's the rationale for the position in the ordinary case. Then at 3780, at 31036.
Sorry, reference again, please.
3780, para 31036 is a page with lots of footnotes and 2 paragraphs is the second paragraph. More generally, the modern relationship of employer, I should have perhaps read the heading to the paragraph, exceptions, employment contracts. Sorry, I was actually about to read from the wrong paragraph, so it's lucky I did stop myself. So 31036, exceptions, employment contracts. The principle stated in para 31033 is subject to a growing list of exceptions. And then over the page, 31037, more generally, the modern relationship of employer and employee is often less personal than the old relationship of master and servant was believed to be. And there are signs that the courts are prepared to re-examine or qualify the traditional equitable principle in the light of this development. They cite various cases, including Hill and Parsons. If one turns to Snell at 4342, unsurprisingly, you're about to read something rather similar. Under the heading Employment Contract, and having explained the basis for not requiring employees to continue in service, second paragraph, neither rationale applies to specific performance of the employer's obligations under the employment contract. Yet, traditionally, they would, and that was really what I meant, my Lord, when I said one of the connotations of general was established in previous cases, many of which are rather old, traditionally they would also not be specifically enforced on the basis that mutual trust and confidence is required in the employment relationship and cannot be forced if it has broken down or a continued relationship is unworkable for some other reason. However, recently the courts have recognised that the employment relationship is not necessarily as personal as it once was, and have shown more flexibility in granting injunctive relief against employers in exceptional circumstances, even where this might amount to indirect specific performance. And again, the next sentence refers to the case of Hill and Parsons. I think if I can take the court to Hill and Parsons, that will occupy the remaining 5 minutes before the short adjournment. It's at 2325.
Can you just give me the extract from Snell again?
Of course, my lord. It's at electronic page number 4342, and it's the second paragraph of internal 17013. So,
and the reference to Hill?
2325. And the court probably knows, but Hill involved an employer who gave notice of termination to some 38 employees, including the plaintiff, because they would not join a particular trade union.
I think I must have got the wrong page number.
Yeah.
Oh,
It's right down the bottom.
it's down the bottom of the page, my
right.
apologies, sorry.
Oh, no, my fault.
Yeah. Yes. If I ever edit law reports, each new report will start on a new page. That case involved, as I say, an employer who gave notice to terminate a large group of employees, including the plaintiff, who wouldn't join a particular trade union. The plaintiff, in sort of a test case almost, sought to injunct his dismissal. So it hadn't happened yet, he'd been given notice. Picking up the judgment of Lord Denning at 2334, at B, he addresses the question, what is the consequence in law of a dismissal in breach of contract? In the ordinary course of things, the relationship of master and servant thereupon comes to an end, for it is inconsistent with the confidential nature of the relationship that it should continue contrary to the will of one of the parties thereto. Then just above E, I would emphasise, however, that that is the consequence in the ordinary course of things, and that remains true, as I say. The vast, vast majority of threatened dismissals are where the employer has lost confidence in the employee. The rule is not inflexible. It permits of exceptions. The court can, in a proper case, grant a declaration that the relationship still subsists and an injunction to stop the master treating it as an end. And then over the page between A and B, it may be said that by granting an injunction in such a case, the court is indirectly enforcing specifically a contract for personal services. So be it. At 2338 G, Lord Justice Sachs, agreeing, noted that in support of the defendant's submission, reliance was naturally placed on a number of statements in general terms in judgments entitled to a special respect. And he refers to a judgment of Justice Jenkins in Vine. And then we say pertinently to the submissions of the respondent, noted at the top of the next page that Lord Justice Jenkins would have been the first to deprecate overextended reliance on words spoken in general terms, for he himself had the year before said, it is an abuse of authorities to extract from judgments general statements of the law made in relation to the facts and circumstances of particular cases and treat them as concluding cases in which the facts and circumstances are entirely different and which raise questions to which their authors were not directing their minds at all. And note in passing that at 2340, between A and B, Lord Justice Sachs considers expressly, I would say it's clearly implicit in Lord Denning's judgment as well, but expressly considers what the position might be at a final hearing, saying, consequently, he, the plaintiff, will in all probability be found entitled to relief in the shape of such injunctions or declarations as may be appropriate at the date judgment comes to be given. So, the ordinary principle, if you can call it that, certainly the general case, numerically speaking, in employment cases is that a master cannot be required to retain in personal service a servant in whose morals or capacity he has lost confidence. And that is the situation in almost every case in which an employee has complained to the courts that their employer is about to dismiss them in breach of contract. However, that principle had no application in Hill, and even less application in the present case, where both the employer, this really is unique in this regard, both the employer and the employees self-evidently want the relationship to continue. The only difference between them being whether it should continue on the current terms as to pay or on worse terms as to pay. And I think, my Lord and my Lady, that is one o'clock.
So there's no loss of trust and confidence by the employer in the employee in this case?
The respondent has not expressly conceded the point, but I take it as self-evident.
And the employer's entitlement, or a bit more, his ability to dismiss in the event of such a loss of trust and confidence would be unimpaired.
I mean, maybe I'm too hesitant, my Lord. What I should have said is the employer wants to re-engage the employees. So the employer wants them to keep working. The employees have injuncted the employer from dismissing them, so they want to continue working.
Have we reached a convenient moment?
My Lord, yes.
Very well. We'll adjourn and resume at 2 o'clock.